Frank, and I'm a bankruptcy lawyer. We've really divided up the presentation into two different segments. One is non-bankruptcy issues, which then will flow into bankruptcy issues. My son, Matt Frank, will handle the bankruptcy issues. I'll start off with sort of the non-bankruptcy issues, but I think you'll see that one works into the other. We are governed by Michigan state law on debtor-creditor rights. Debtors are people that owe money, creditors are people who are owed the money. There are basically two types of creditors. There are secured creditors and there are unsecured creditors. Secured creditors have liens. A bank who has a mortgage on a house is a secured creditor. A bank or a credit union who has a lien or is owed money on an automobile is a secured creditor. Secured creditors have more rights and different rights than unsecured creditors. Secured creditors can go to court and get an order of a court to require you to turn over their collateral. That's that which they have a lien on. Secured creditors, most typically, when they have liens on cars, you've all heard of the repo man who repossesses the car. They don't have to go to court to repossess the car. However, they have no right to seize the car if it's on your property. You tell them to go away. They can't break into a garage. There's a lot of limits. They're allowed to use. They're not allowed to use what's called self-help. But if the car is on the street, they can come by and pick it up. If the car is in a driveway, they can come by and they can pick it up. When it comes to houses, for example, the only way they can't grab a house, they can't take possession of a house. They have to go through a formal foreclosure process. It takes quite a while. And after there is a notice of foreclosure and a foreclosure sale, which takes about 5 weeks, the owner of the house, who's called the mortgagor, has the right to stay in possession for an additional 6 months. Basically rent-free. You don't have to pay taxes. You don't have to do much of anything, and you can just stay there. That's the law with regard to houses. With regard to cars and other items like that, you don't have that kind of protection. The vehicle can be seized and sold within about 14 days. Matt will explain to you how you can stop all that, but and you can do that with a bankruptcy petition. But I'm going to identify what goes on without a bankruptcy. With unsecured creditors, you signed a promissory note. You signed a one of those payment upon pay items. You owe money on a medical bill. Basically, unless you've given someone a lien, and that has to be done with a certain type of piece of paper, they are general unsecured creditors. They have no remedy against you short of going to court and getting what's called a judgment. They can't just knock on your door and say, pay me. You can tell them to go away. They can use collection agents, but collection agents have their limits. And there are laws that protect you against harassment from collection agents. But a collection agent basically doesn't have any ammunition, can't really make you pay. They can just call and be very, very annoying and threatening. But they really can't get paid. For an unsecured creditor to actually get paid, they have to file a lawsuit. The lawsuit has to be served upon you. You get a summons and complaint. You have 21 days to file an answer, which you should always do. If you don't file an answer, they'll enter what's called a default. 21, usually 22 days after you were served. Once they get a default, they can enter what's called a default judgment. Once a judgment's entered, again you have 21 days before they can do anything, but on the 22nd day they can collect. Generally, unless you have an awful lot of assets, the really main way to collect on a judgment is through a garnishment. A garnishment is basically a piece of paper that is served upon somebody who owes you money. Typically, it's your employer. Also could be a bank if the judgment creditor, it's called, has enough information to know where you bank. They could issue a writ of garnishment on the bank. The minute the writ of garnishment is received by the bank or by the employer, they're required to hold back your money. If it's a bank account, they will freeze your entire bank account until they get paid. If it's a employer, federal law and state law states that they cannot garnish more than 25% of your net after-tax income. So there's on the writ of garnishment, on the back end of it, you'll see a schedule that says how you calculate out what's due and owing. But ultimately, it's 25%, no more than 25% of the net after-tax income. And if there are 10 writs of garnishment, it's the same 25%. It just gets divided up as to who got there first. With a judgment, you can also seize an asset. Perfect example would be you have an automobile. It's easy to find an automobile because they're all registered with the state. The registration, the title shows whether there's a lien on that or not. If there's no lien on it, they can send someone over to seize the automobile. They have to get permission of the court, but that's automatic. If they do that, you'll get a notice of a sale, almost no notice at all, and you'll lose it. So far I've been discussing the remedies creditors have to get paid. Now I'll turn to the remedies debtors have to not pay. First of all, under Michigan state law, there are exemptions from collection on judgments. You get $1,000 basically on an automobile, your furniture, your tools of the trade if you were a carpenter, for example. There's a whole list of exemptions. The most important exemptions are, for example, disability insurance payments are completely exempt. Social Security payments are completely exempt. If you have an IRA or a 401k, it is completely exempt. They cannot touch it. And I'll just give a little complicated example of something, but you have a bank account. You're getting direct deposit from the Social Security Administration. Say it's disability payments, or if you're someone as old as I am, you get your regular pension from Social Security. The proceeds, which are the money that then sits in the account, is also exempt. But the bank doesn't know, the bank doesn't care. The creditor who, let's assume the creditor finds out the bank account, issues a writ of garnishment, serves it on the bank. You are supposed to get notice of the writ of garnishment, and let's assume that 100% of the money sitting in that account came from Social Security, or your disability insurance, or from whatever. You can object to the garnishment on the basis that, hey, this is exempt. This is Social Security money. You have to go to court. It's not easy, but as long as you establish it as long as you file the objection and go to court, that money will be freed up eventually. And the other people, the creditor, will not get it. Another remedy you have is the right to pay a judgment in installments. Most of the courts have a form you can fill out requesting the right to pay the judgment in installments. At that point, if a installment payment order is entered by the judge, it stops all garnishments as long as you make those payments. And that order basically is up to the judge. You would make the request, but it is not limited to the 25%. So when you look at the forms, it shows what is my income, and if it's not otherwise exempt, because if it's exempt you don't have to worry about it, but if it's not otherwise exempt, here are my expenses. I have unusual expenses. These are my problems. This is what I have to deal. I need to pay for medication, whatever it may be. You list those out, you appear before the judge, and you explain it to the judge. The judge can do whatever the judge wants within reason, but the judge could say, okay, you're going to pay this $5,000 judgment off at $1 a month or $10 a month. I mean, they have that ability, and I've seen that happen. Sure.
Jerry, when you talk about the judge in court, what court is this, and how easy is it to do this for folks who may not have an attorney? Is it something they can do themselves?
It is something you can
need
do.
to repeat the question.
Oh, the question is, what court am I talking about, and can people do this without an attorney? Thank you. Generally, we're talking about, in Michigan, it would be called a district court. District courts handle claims $25,000 or under. At least for now, they have clerks. We just got notice yesterday that they're talking about making the district courts electronic so they can get rid of a lot of clerks. There'll always be a clerk there. But basically, if you get a notice, let's say, I'll give you the perfect example. You get notice of a writ of garnishment. Writs of garnishment, let's say it's served on your bank. Your bank is supposed to and is required to give you a copy. I can tell you that 50% of the time they don't do that. They'll notify you that they've received a writ of garnishment because they'll put a freeze on your account, but you're gonna, even though they're required to give you a copy of the notice, they don't. The attorney for the plaintiff who gets the writ of garnishment has no obligation to give you notice of the garnishment, but if you call them, they'll have to. You get a notice of the writ of garnishment, and we'll use my example, 100% of the money in that bank account is Social Security disability money. You file an objection, and the way to file an objection is you're going to, unfortunately, have to go to the court. They'll give you a form, and you'll fill it out. They're not supposed to help you. Usually they will. You fill out the form, and you have to file it, and then you have to mail a copy to the other attorney and a copy to the bank. Generally, after that, you'll get a notice from the court in the mail of a hearing and where to go to in a courtroom. If you live in the city of Detroit, you're stuck with the 36th District Court, which is a very, very, very busy court. It's right off of Woodward. It's in the old, I think it's the old Hudson's Warehouse building. And it is difficult to navigate those courts, even for lawyers, believe me. You're going to spend a day, and it's not easy, but it can get done eventually. If a trickier petitions to pay in installments, generally you can pick those up from the court. Fill them out right on the spot, and you hand them to the court. You have to make a copy because you have to mail it to the attorney on the other side, and you have to ask the court, when am I going to have a hearing? How will that take place? Each court's a little different about it, but they generally send out notices to your address. The important thing is not to sit on your rights. You get notice, you have to do something about it. Even when a judgment's entered, you have to do something about it, and you have a certain period of time to do something about it. Yes?
Question, you described a situation where all of the proceeds in a bank account, let's say, came from Social Security or disability. How difficult is it when the money has come from more than one source to protect your assets?
Yeah. The question is, what happens if some of the money in the bank account comes from Social Security and some of the money, let's say, just comes from a payroll or a gift or whatever? And how difficult it is to deal with that. It's not easy. You'd have to go to court. and you'd have to go to court. Well, the simple thing is, you should have a record of your deposits. If it's Social Security, it should be identified right on the deposit statement as a direct deposit, because I think Social Security does that nowadays for everybody. Well, they still do some checks they mail, but they're trying not to. But if, for example, there was a check that you mailed, you're going to get something from Social Security. You should have a stub someplace. You can show it to the court. I will tell you, if you're in the 36th District Court, which is affectionately known to lawyers as a zoo, you really have to make yourself heard. Some of the judges aren't very nice. They don't want to listen to you. You have to stand your ground when the case is called. But if you explain what it is, they'll do it. And you know, there is a pro bono list of lawyers, and a lawyer can help you out. But no one's going to want to spend a day there, I can assure you. I've been there, and it's not fun. In some of the suburban courts, they're less busy, it's less crowded, depending on the size of the town, and they can be much more helpful. I've been to courts in Farmington Hills. The clerks are very nice there. Walled Lake, the clerks seem to be very nice there. Birmingham, Bloomfield Hills, naturally, they seem to be quite nice there. Royal Oak isn't too bad. Ferndale's not too bad. Yes?
So we had to file in the area that you live. You can't go to another court
Well, I'll make it even worse. No, you have to file in the court
of your district.
that issued the writ of garnishment or did the judgment. You may not live there. Okay? You know, sometimes people sue people in the wrong place. But once the judgment's entered, it's too late. Sometimes the court catches these things. I was referred somebody, and I got something, I was able to examine what took place, and she was sued in Southfield but lived in Detroit. The judge figured that one out and shipped the whole file to Detroit, to the 36th District Court. But that doesn't always happen. Sometimes some judges pay attention, some clerks pay attention, some don't. You know, everyone's human. But that's the court you go to.
Jerry, would you suggest having a separate bank account then only for somebody's Social Security check and not commingle any funds just because it can become difficult?
Repeat the question.
Yeah, the question is, would I recommend having a separate bank account just for Social Security or disability payments? Absolutely, but even that can be a pain. But once, because these consumer collection law firms, these are generally law firms that for the most part represent credit card companies or people who bought credit card debt. That happens a lot. They're very high volume. They don't pay a lot of attention to what they do, and they just blindly file these things left and right. And getting their attention is not easy, and you're going to be without the use of your money possibly for a month or two. But once you free it up that first time, you're done. Yeah. Same thing, by the way, and I didn't mention this, but it's quite often, perfect example, husband and wife have a joint account. The credit card's only in the name of the husband's the only one that has a judgment against them. There's a presumption at law that 50% of the money in that account is the husband's and 50% of the money in the account is the wife. If 100% of it's the wife and you prove it, then the garnishment will have to be discharged. You go to court to do that. It's not easy, but you can do that. You can show that. Here's the deposits, here's my pay stub, for example. Unfortunately, well, in the old days, I've been doing this kind of work for 40 years. In the old days, banks were very careful. And if they were served with a writ of garnishment against a husband and it was a joint account, they would disclose, we don't know how much we owe the husband. Nowadays, unfortunately, and perfect example, when NBD existed, National Bank of Detroit, you had a local person responding to these garnishments based upon local law. The last I saw, Chase Manhattan Bank, which now owns the old National Bank of Detroit, has a garnishment center in Baton Rouge, Louisiana. And they'll tie up the money, and even though it's a joint account and there's only one a judgment against one of the people on the account, they'll tie up the money, and if there isn't a response, they'll write a check right away to the creditor, which is unfortunate. But you have to, and by the way, many people use bank accounts as a cheap method of estate planning. The daughter or, of a mother may be on the account.
Your attention please. Like me on law for Reagan support group.
So-
Meeting tonight and every Thursday night from 6:30 p.m. until 7:30 p.m. in the Harper Hospitality Suite 1. All are welcome. Your attention please. Like me on law for Reagan support group will be meeting tonight and every Thursday night from 6:30 p.m. until 7:30 p.m. in the Harper Hospitality Suite 1. All are welcome.
The law itself today still provides a balance and protection to debtors. Unfortunately, the system doesn't do a very good job of it anymore. Very different than when I started practicing law. We live in a mean world, which is unfortunate, but that's the way it is. So you have rights, they're there, but you have to assert them.
The 50% presumption belonging to the husband or wife, does that 50% ownership apply to other relationships, parent and child, or just two people, period, or?
The question is, the presumption at law of 50-50 between husband and wife, does it apply to other people? Yes, it's the same.
Oh.
If there's 3 names on the account, it's 1/3, 1/3, 1/3. Now, it's a presumption. Now, a presumption just means that it's presumed to be that way. It can be what we call in law rebutted. If you show, like my example, if a husband and wife have a joint account, judgments against husband, wife shows that 100% of the money that gets deposited is from her paycheck, that presumption's rebutted and 100% of it's considered to be hers. So, yes?
I have a question. Now, back to what you were saying earlier. Sometimes that's the case and sometimes not. My daughter and I have the same first and last name, but my daughter have a middle name. My daughter got caught up in a car scandal. And when she got caught up in the car scandal, what it was when she went in, she had an 81 credit account. But it was someone else that wanted the car who did not have that account. So in turn, they ended up getting 2 cars. And they all went up under my daughter, but my daughter was too young to get the second car. She was supposed to be 25, and she wasn't even 21 at that time. She was all over. Somewhere or other, they went to try to get my name for the second car, but the insurance was my daughter couldn't do it. But they couldn't get it because at that time, they didn't realize I didn't even have a driver's license, so I wasn't any good with them. But I got caught up in the system. And now our thing keep intertwining when I try to tell people that, first of all, either they assume that, well, either you trying to use the daughter name or you trying to get on over us. But she trying to, but they call us up in the system, and I keep saying, you always got us mixed up in the system, but they won't take out the time and listen to, I have paper and everything. So how do you know that?
Well, the question's a little complicated, but I think I can simplify the question is what happens when there's identity fraud or a mistaken identity. It is very difficult because you're right. The creditors don't listen to you. The bottom line, though, is if your signature's not on something, you shouldn't be made liable. If your signature's on something, you should be made liable. Matt will discuss, because even though he's doing the bankruptcy side of things, Matt has the expertise on credit reporting, which is a whole different world, which I think is what you're talking about. I'll give you a very simple example. My daughter ended up with a judgment on her credit report about a debt that couldn't possibly have been her, dealing with somebody with an address, 50 miles away from where she lived at the time. It's not so easy to get these undone, and you have to work very hard to do it, and it's not easy to do on your own. And unfortunately, the amount of money at issue doesn't justify paying an attorney. So you just have to dog ahead, and just frankly, just like collection agents annoy people to get paid, you have to annoy the clerks of the court before you can do it. But Matt will talk about credit reporting, because that's a whole different world. Any other questions for me?
If you could just repeat, because they had the announcement going on, you were talking about something earlier related to the secured creditor, a mortgagor, the mortgagee being able to stay in a house an extra 6 months after something happened, and that's what I missed because of the announcement that was going on. There was some interference, but you talked about the foreclosure situation and the idea that they have to go to court to get the judgment.
No. Okay. The question is, and I'll repeat it, and I'll expand upon it. You're in default on your mortgage on your house. What happens? And what rights do you have? What rights do the lender have? The legal term is the person who owns the house, who grants the mortgage, is the mortgagor. The mortgagee is basically the bank. And typically today, in the whole metropolitan area, houses are worth less than they were worth 5 years ago, 10 years ago. It's fairly typical that the mortgage the mortgage debt is greater than the value of the house. So you're not going to sell the house and pay off the lender. You're not going to be able to refinance and pay off the lender. I think I'll talk about the whole mortgage situation because it's easy to do. There are various government programs that put pressure on the lenders to modify mortgages. There are judgments that were entered in various court proceedings throughout the country that compels certain lenders to do modifications. And these are modifications where you could actually stay in your house. Unfortunately, the lenders play games. They don't comply with federal law, and they're not complying with the judgments that were entered. I can tell you I'm working on one right now where Bank of America over a year ago entered into a judgment with the United States government that required them to do loan modifications. And luckily for my client, we're in court, but Bank of America hasn't even set up the system to do it. They're trying to get around it, and there's newspaper reports on it. But again, you just have to dog your way through these things, get these modifications. And some of these modifications for the bigger lenders require them to reduce the principal amount you owe, allow you to pay over 30 years, lower the interest rate to 3%. You can stay in your house. But let's assume you're in default, you can't pay, you have no income. What happens? Generally, sooner or later, the lender will foreclose. In this state, you can foreclose by what's called advertisement. You don't have to go to court, and most lenders don't go to court to foreclose. They have to post a notice on your front door, and that's the only notice you'll ever get. They have to advertise in the Detroit, if it's Wayne County, it'll be in the Detroit Legal News. If it's in Oakland County, it's in the Oakland County News. If it's in Macomb County, there's a Macomb County News. It's in the classified section. You'd have to know where to look to find it. Long legal notices, but that's what takes place. After 4 consecutive weeks of publishing the notice, they can then go to basically the sheriff conducts a sale in the courthouse. Each county does it on a different day of the week, but if you walk into and this is now circuit court, before we were talking about district court, circuit court handles cases over $25,000, and they also handle mortgage foreclosures. And if you go into the Wayne County building on Woodward and Jefferson, you'll see posted in the clerk's office notices of foreclosure, and they'll act on the day of foreclosure, and I don't remember what day of the week it is, there'll be someone sitting there actually auctioning off houses. Normally, the lenders bid on these foreclosure sales. And every dollar they bid to purchase that house is $1 less you owe. It's called a credit bid. So if you owe $100,000 and they bid $90,000, once they bid and they purchase the house at the foreclosure sale, you only owe them $10,000. Dollar for dollar bid, and they have to record a sheriff's deed. That shows you how much they bid. And the question really was about the right of redemption. You have the right after the foreclosure sale to stay there for 6 months. They can't evict you, they can't do anything. You have that right to be there for 6 months because you can redeem from the sale. And once the 6 months is up, traditionally these days, they call it cash for keys. The lender's agent will call you on the telephone and say, we'll give you $1,500 to leave. And you take it. Because otherwise they have to go through an eviction. They go back to the district court and evict you from your house. You don't want that to happen. And even then you get another 3-4 weeks, but you don't want to take it that far. A lot of times, and it's not nice and it's improper, they have a new law that says your 6-month right of redemption is cut down to 2 months if you abandon the house. People will get a letter from the law firm saying, this confirms the fact that you've abandoned your house. Well, you haven't. You're sitting there. You respond. Okay? Because otherwise, they'll play games. They'll file an affidavit of abandonment, and they'll try to seize. Then they have to try to evict you. But if that took place, you could show up in court on the date of eviction and say, no, I didn't abandon the house. I still live here. The affidavit was fraudulent. And the judge should deny the eviction. But you know, the bottom line, I think I'm trying to explain to everybody, is you can't sit on your rights these days. You have to do something. You have to exercise them. I guess since we're on the mortgage thing, I might as well explain the last piece, which is, can you get sued for the balance at the end of the day? And you can, but, and it's interesting, at law, if the foreclosure is by advertisement, they can only sue you for the difference between the fair market value of the house and the debt. So if they bid $10,000 on a house worth $100,000, they can try to sue you for $90,000 because that's what's called the deficiency, the loss, but you have a defense to show up and say, Judge, the house was worth $100,000. It doesn't matter what they bid. So that helps, and it's helpful if it ever comes up, because it's not exactly easy to establish what the fair market value of a house is these days. You know, you can usually come up with 10 values for the same house. Any other questions? Because now we turn to Matthew Frank.
Okay, well, I'm going to talk about bankruptcy, and I'm going to try to explain it because it can get very, very complicated. So I'm going to try to explain it as simple as possible, and hopefully in a way that everyone can understand it. People are aware, they hear this concept, bankruptcy, but they may not know exactly what it means, how it works, what it does. They just know it deals with their debts. That's kind of the general understanding of bankruptcy. It was kind of evolved out of the free market enterprise system 500-600 years ago, when they used to in England send people to Australia for debtor's prison. It just didn't work. It's society, it just didn't make sense. So they needed a system to allow people to kind of put their past behind them and move forward and not be punished for things that are out of their control, like losing a job, medical bills, just house fires. There's all kinds of things that can cause financial problems that are just frankly out of all of our control. So the bankruptcy system, the way it works is there's different types. You've probably heard in the news like Chapter 7, Chapter 11, Chapter 13, and they're all a little different, and they all work kind of serve different purposes. And really, I should back up because bankruptcy is not appropriate for everybody. Just because you may have some debt doesn't mean you should file bankruptcy. It really is appropriate for people that can't afford to pay their debt as it becomes due, or have too many assets kind of at risk that you want to protect, and you still can't pay everything back, but through a bankruptcy you can buy some time and kind of force your creditors to accept that payment plan. It just depends on the chapter. When I was taught bankruptcy, after years of working in the field, because I worked for my father before I went to law school, but in law school, my bankruptcy teacher drew a picture of a timeline. And the timeline really conceptualized bankruptcy to me and made me understand it way better. And I can't really draw a picture right here, but if everyone could just kind of visualize a timeline, I think we all know what that is, and you pick a point on that line. The way bankruptcy works is it's like you take a snapshot of everything that happened up until that point. And that's what the bankruptcy covers. So all your debts that, let's just pick that point of time is March 15th, 2013. So on the timeline, all your debts that you owe up until March 13th, if you file bankruptcy on March 15th or whatever, would be subject to the bankruptcy proceeding. Any debts that incur after that date are not part of the bankruptcy proceeding. And the other important thing is the day that you file this thing, I like to call it a force field. The bankruptcy court calls it the automatic stay. But basically, it's a force field, like in Star Wars when people shoot at spaceships and they put up those made-up force fields to protect them from the bullets. The automatic stay is basically that to protect you against your creditors. So if your creditors are suing you, if they're calling you, if they're trying to repossess your vehicle, if they're trying to garnish your wages, by filing a bankruptcy petition, it stops that activity. They can no longer continue calling you. They can no longer garnish your wages. It's all subject to the bankruptcy proceeding. They could go in the court and ask for permission to go back and do it, but there has to be kind of certain circumstances in order for them to do that. Most of the time, they're pretty much stopped and stuck with the bankruptcy proceeding. The big exception is foreclosures. When a house is in default, if you file a bankruptcy before the foreclosure sale, for example, let's stick with my March 15th date. Let's say a foreclosure sale is scheduled for March 20th. If you file bankruptcy on March 15th, that cancels the foreclosure sale. And the bank would have to go into the bankruptcy court and get the court's permission in order to start going through the foreclosure process again. So it's a way sometimes to buy some extra time. If you know you're running out of money and you're going to have to move out, but you can time it and buy yourself some extra time, frankly, by filing a bankruptcy prior to a foreclosure sale. So that's kind of how the automatic stay works in a nutshell. And it applies to all the different chapters of bankruptcy, whether it's a 7, 11, 13, regardless of the type. I'm going to back up again because I started talking about bankruptcy is not appropriate for everybody. It's appropriate for people, I guess, that have something to protect, or like wages from being garnished, or vehicles from being seized, or just from creditors calling you every day and driving you crazy. A lot of people may be uncollectible. They may live off of their pension and Social Security or other benefits that are protected that creditors can't touch, but you live with the headache and the anxiety and this weight on your chest of these creditors hanging out over you. And they're still going to call you even though they know they can't get anything from you and drive you crazy. So you can file bankruptcy. Now, depending on your income and the amount of assets you have, determines the chapter that you file. And that's where we'll get into Chapter 7, Chapter 11, and Chapter 13. Chapter 7 is basically when your income, and it gets much more complicated, but in simple terms, it's when your income is either equal to or less than your monthly living expenses. That's kind of the main hurdle that you have to go through in order to qualify to be in a Chapter 7. I prefer my clients to go through a Chapter 7 if they qualify, because you're in and out of the bankruptcy court within 3 to 4 months typically. You rarely pay anything back to your creditors, so it allows you to kind of get your fresh start as fast as possible. And let me see. And what happens in Chapter 7 is called a liquidation. So my father was explaining, under the state law, you can exempt certain assets from your creditors. They're not allowed to touch like $1,000 in a vehicle or whatever. In bankruptcy, you can assert those exemptions. So even though people have assets sometimes, you still can retain them. It's not like you file bankruptcy and everything you own gets handed to someone and they auction it off and you have to start completely from fresh. You can usually keep a vehicle. It depends how much equity you have in your assets. And it depends, you have either exemptions through the state or federal system. You can either do one or the other. And exemptions get very, very complicated to explain. But the easiest way, I guess, to think about it is a house. Under Michigan law, if you own a house by husband and wife, and it's deeded by husband and wife, it's completely exempt from your creditors to the extent that the debt is only to one of the homeowners. So if the husband and wife are both liable for a particular debt, that creditor potentially could get to the equity in the house. But other than that example, the house is completely protected. So you could have theoretically a house that's worth $10 million and still file bankruptcy and get rid of all of your debt. I mean, that's really not the situation for most people. That really doesn't happen, but you could. So that's state exemptions. Under the federal exemptions, you can exempt up to $125,000 of equity into the house, but there's certain exceptions and definitely gets very complicated. You can exempt $20,000 no matter what, and that's equity would be above and beyond what is owed on a mortgage. So if the house you owed was worth $150,000 and you only owed $100,000, there'd be $50,000 of equity. So under the federal law, without any complication, you'd be able to protect $20,000 of that equity. Unfortunately, most people in Michigan have no equity in their house, so it's really kind of a moot issue. But under the federal law, you could also protect up to almost $11,000 of equity added up all together in many different assets. So you could have a bank account with $11,000 in it and be able to protect it. You could be entitled to a tax refund of up to $11,000 and be able to protect it. So my point is, you could file a Chapter 7, even though it's called a liquidation, you still can retain most of your assets. 99% of the cases are what's called non-asset Chapter 7 cases. In every case, people have furniture, they have clothing, most of the time they have vehicles, and most of the time they get to keep them. If there's something that you cannot protect that's not exempt, a bankruptcy trustee is involved in the case, and their job would be to liquidate those assets to cash to distribute to your creditors. And you would get, like, let's say You could exempt $3,000 of equity in a vehicle, but a trustee could sell it for 10. You would be entitled to the first 3,000. The rest would be distributed to your creditors based on there's different priorities. So that gets very complicated also. And I don't, unless you guys have questions, I don't think it's really necessary to get into detail of that. The other, kind of lost my thought for a second.
Discharge.
Oh, so the main goal in any bankruptcy is to get your debts discharged. And as I said earlier, Chapter 7 I prefer because you get your discharge the quickest. The way it works is on our timeline, March 15th, that's the day that the case, the imaginal case that I'm trying to explain would be filed. Usually from that day, there's a 90-day window that your creditors have to challenge your ability to get a discharge. If they don't object to your discharge, the court automatically will generate an order, and all the debt up until that, during that picture of time, up until March 15th, becomes discharged and you no longer owe it. It's gone forever. Your creditors can challenge your discharge on a number of grounds, but typically they have to do with committing fraud, not disclosing assets, maybe borrowing money under false pretenses, lying about your assets and applications. But rarely do we see that happening. But there are a lot of specific debts that are deemed non-dischargeable. When we're talking about general credit card debt, as long as it's 90 days older than the day from the case was filed, that's completely dischargeable. Most creditors, if they have a judgment against you, that's discharged in bankruptcy, even though they went through the legal process and obtained a judgment. Even if they have garnished wages, you still can discharge them in a bankruptcy. Debts that are non-dischargeable would be debts like student loans, tax liabilities, child support payments, alimony payments, certain criminal penalties. And with that being said, there's exceptions to all these rules. Student loans typically are non-dischargeable, and it's very hard to get them to be deemed dischargeable. In order to do that, you have to file a lawsuit within the bankruptcy case, and you have to show basically that whatever the loan was borrowed against, that you will never be able to work in that field ever. So, I mean, medical problems could be a good basis for it, depending on what they are. Getting in a real bad car accident and not being able to work ever again would be a good basis, but they have to be very extreme. You can't just say, I can't afford it right now in order to get rid of student loans. Yeah.
So I think that's a really good point because unfortunately, Matt, what I've seen is I've had some cancer patients go back to school and then unfortunately their cancer has now progressed and they're never going to be able to go back to work, to be able to do any kind of work related to why they went back to school. Can you talk a little bit about how you get that loan discharge?
Okay. I'll explain it, and the first thing I'm going to say is the question was how you go about if someone does suffer from a problem with their student loan or ability to work in the field that they got their loan in, how do you go about to get that discharged? If you don't do anything, it's automatically deemed non-dischargeable. So you have to take action, and it's within the bankruptcy case. You have to file a lawsuit against the bank or whoever you owe the money to, basically pleading your case. And ultimately, a bankruptcy judge will make the decision of whether they think your circumstances meet the criteria in order for the debt to be dischargeable. It's not easy and it's not very cheap. Unless someone's going to do it pro bono, it can cost a lot of money. The way litigation works is you never kind of know what your opposing side is going to do. If they don't fight you, chances are it won't cost much money. You can kind of move it through the system quickly. But usually we're dealing with a lot of money, and I imagine most of the time they are going to fight you. And I mean, it could cost $10,000 to $20,000 in legal fees to fight it. And if the student loans are $30,000, I don't know that I would recommend that, because the risk and the cost, I don't know, would be there. It would really depend on the circumstances.
Can you only get your student loans discharged if you go through bankruptcy?
There's, from what I understand, there's different federal programs related to the question was, can you only get your student loans discharged through bankruptcy? And the answer is no. One way is to pay them off, but you wouldn't be listening to me if you could do that. So I believe Obama enacted some program about a year ago that as long as you were current with your federal insured loans, I believe after a certain point they waive whatever the balance is, like after 20 years or something. But it's very new, so I don't have a lot of knowledge about it. And I'm sure depending on the lender and the program, they probably do have different, I know they have programs where you can get payments deferred. So they'll put you in a category where they say you're uncollectible, but they'll still consider you liable for the debt, and it doesn't disappear. But I imagine there's probably some that do have programs where they will write them off, but that's really something that you would have to dig into based on whoever you borrow the money from.
I guess the reason I ask is I wonder how often people come to you thinking that they need to file for bankruptcy, and maybe you help to educate them on there might be other ways they can deal with their debt. Does that happen very often?
Well, the question was, when people meet with me, and I guess I'll answer it and restate it. Usually when I meet with consumers, they think that they have to file bankruptcy. That's why they're coming to me. But bankruptcy is not always the answer. And like I said earlier, depending on your income, but debt also plays a role on it. If your debt is primarily student loans, you're not going to get a benefit from filing a bankruptcy unless you have some way of fighting to try to get them discharged, which is not easy to do. So I guess the answer is it's not easy. Taxes, general income taxes are dischargeable if they're 2 years old since you filed your return, or since the IRS has assessed you. So right now it's 2013. If you filed a tax return in 2010 or earlier and you owed money for income tax, you could discharge that in a Chapter 7. If you were assessed within the 2-year period, that debt cannot be discharged in a Chapter 7. So if you owe like $50,000 in income tax liability for 2011, you're not going to be able to discharge that if you file bankruptcy now. 2 years from now, you will be able to, but not right now. So it's a case-by-case analysis for me. I've created a really long questionnaire. So when I meet with people, it allows me to kind of filter through all these things to figure out what is appropriate for them and what's not. And a lot of times I meet with people and I say, I don't think bankruptcy is going to work for you. You have too much at stake, or you have nothing to benefit from it. For example, someone like in their 80s that doesn't have a lot left in their life, there's really no benefit, especially if they just have Social Security that they live off of and they don't have a lot of assets. A bankruptcy is really not going to do much for them other than kind of really put their creditors to rest. But other than that, there's no benefit. If you're younger and you need to move on in your life, you don't want these debts hanging out there forever. It will make sense to file a bankruptcy, and I would recommend it, of course, depending on all the other circumstances. Also, if your income is too high, sometimes people get really caught up in debt and have a lot of debt, but they also have a lot of income. And a Chapter 7 is just not going to work for them because their income exceeds their necessary expenses to live off of, And that's kind of the first hurdle in order to qualify for a Chapter 7, which actually leads us into the other types of bankruptcies. There's what we said earlier, Chapter 13 and Chapter 11. And we hear a lot probably in the news of like Mike Tyson's and the Michael Vick's filing bankruptcy. And what they do is what's called a Chapter 11. And that's really designed for businesses. And it's an opportunity to reorganize, kind of put a package together. You know you make too much money, so you can't do a Chapter 7. So in a Chapter 11, you put this plan together, and it gets mailed out to all your creditors, and the plan explains how each creditor is going to get paid. And they're put into different categories. Like your lender on your house is a secured creditor, and they'll be in their own category. Your credit card debt, all your unsecured debt kind of gets put into another category. Taxes are in a separate category. So all the creditors get this plan on how you propose to pay them back. And then they could vote on the plan and fight with you about it. And a Chapter 11 is very expensive. We do a lot of business reorganizations, and that tends to be the volume of Chapter 11 work that we do. It's very uncommon for individuals to file Chapter 11s, other than the Michael Vick and Mike Tyson, or the type of, like a doctor, someone that makes millions of dollars or has millions of dollars in assets. It makes sense for. If your debt is less, your unsecured debt is less than $1 million, you qualify for what's called a Chapter 13. And a Chapter 13 is basically like a Chapter 11, but it's designed to be much more cost efficient, and it's a much quicker system. Your creditors don't get to vote when you put the plan together. They can object to it, but they can't vote on it. And usually a 13 works well for someone that makes way more money than what their expenses are, but it doesn't make sense for them to incur the expense of filing a Chapter 11. A lot of times we hear about these companies that do debt consolidation programs, and unfortunately my experience with them has been pretty negative, because it's when people come to me when they've had bad results with them. So I don't want to say that they never work and they're bad, because I'm sure they do work and they benefit people sometimes. But go ahead.
Is Green Path considered a debt consolidation?
Green Path is a debt counseling, and I believe that they do debt consolidation. They're a nonprofit. The question was, is Green Path considered a debt consolidator? And the answer is, I believe they do that, but they also do just general counseling with people to try to help them figure out how to budget their money, and they do a lot of things related to debts, basically. And I believe they do that. But the way that works is, these companies will, usually they look at your income and your expenses, and they say, we think you're able to pay like $500 a month to your unsecured creditors. And what you do is you give them a check every month, and they put it into a bank account. And then they start to try to negotiate with all your creditors. And there's no guarantee your creditors will settle with them. Sometimes they're successful, sometimes they're not. And that's why my experience is when they're not successful. So I'm sure there are times that they are successful, but it's probably dealing more with just general credit card debt, and not like medical bills and other types of things that a lot of people face, that can get really large. I think that they probably have ins with certain credit card companies, so they can call and they know that they're going to accept 20 cents on the dollar every day of the week. With like a doctor bill, they don't know that because they're just not set up. It's such a smooth system. So a Chapter 13 kind of forces all your creditors to accept the payment plan and the program. So that's kind of doing your own debt consolidation and forcing it on the creditors. And go ahead.
Just wondering, with Chapter 13, you do this
whole thing where you consolidate and you figure out how much a month? Who determines, once you know X number of dollars a month is gonna go towards your bills, who is it that distributes that money to your creditors?
Okay, the question is, in a Chapter 13 scenario, when a debtor, the one that owes the money, pays in every month to a plan, who decides what creditor gets what, and who makes a distribution? Who decides who gets what is based on the plan, which I was talking about, and your creditors can fight that if they want to try to challenge it. And there's a trustee also involved that oversees Chapter 13s. In Detroit, I think we have 3 Chapter 13 trustees. So every case that's filed randomly gets assigned to one of the trustees. And their job is kind of twofold. Well, they do a lot. But the major thing that they're doing is determining that you're paying as much as you can to the plan every month. And then they kind of administer that you're making those payments, and then they make the payments to the creditors based on what the plan says.
Okay, the trustee is part of the court system.
Kinda. The question is, are they part of the court system? They're a mechanism that's necessary for Chapter 13 to function, but they don't work for the federal government. They're kind of like contracted by the feds. Their income is capped out, but they're not like a federal employee.
Okay.
And in Chapter 7, there's even less balances. They can sky's the limit in the money they make doing it.
Okay, now let's take this a little further with Chapter 13. You have car debts, mortgage payments, and really no credit cards, but you have bills that are being paid for through the trustee. You submit a check every month in the dollar amount that was
Agreed on.
Okay, you're going through your bankruptcy, you're 3 years into it. One of the bills, the car note, is paid off. Now, you don't get that money back. It's continued, like $700 a month. That doesn't change.
I got your answer. I think I know your question.
What's my question?
Do you have to keep paying that same amount to the...
No, that's not
Okay.
my question.
I'd like to try to remind.
I know you have to keep paying. My question is, all of a sudden, you're still paying the same amount, but the bills aren't getting paid. At the end of the 5 years, you discover that for the last 2 years of that bankruptcy, the mortgage was not being paid at the same amount as the first 3 years. So therefore, what should have been paid off isn't, and the bank attorney admits they made a mistake by not letting anybody know that for the last 2 years, the principal was not being paid. My question is, how do I find out where'd that money go? It wasn't coming back into my paycheck.
Okay. The question is, and let me know if I got it wrong, but basically, if you're making payments in a Chapter 13 plan and it doesn't get distributed to all your creditors, is that basically the question?
No, it was being distributed not properly.
Okay, so it's not being distributed properly.
Yeah.
What determines what's proper is the plan, the terms of the plan, and every creditor, when a Chapter 13 is filed, has to file a claim with the court, a proof of claim. It's a form that says we're owed X dollars, and if it's like a mortgage, it says it's secured by a house. So when you do the plan is all refers back to the claims, the proof of claims that are filed with the court. So under your scenario, if the bank screwed up and didn't file a proper claim, that would be their fault, and they're subject to the terms of the plan, and that's their problem.
But everything was fine for the first 3 years. It was according to plan. The last 2 years, something happened
whether it was the bank or the trustee.
Well, the question is, so what happens if, like, in a plan, 2 years into it, something goes wrong with payments and one of the creditors that's supposed to get paid stops getting paid or gets paid the wrong amount?
Right.
What happens? The system's supposed to work perfectly, so theoretically that should never happen.
Well, we know that.
And really, I've never seen that happen before.
And it has, it happened to me.
Okay, and what they do is, if it's a trustee's fault, if the debtor, and nowadays you don't write a check to the trustee, they actually withdraw the money directly from your pay stub. So,
Right.
so you have no control over that. That's basically the trustee's job, and they're the fiduciary. And if they screwed up, they're responsible. And the debtor, I guess, would have a claim, and the creditor also would have a claim. I don't know how that ended up playing out in your situation.
Well, we haven't done anything because the attorney said that we had no recourse. And I don't believe that. That was my money. That was
I don't
not
believe
the-
that there's no recourse either, and
I mean, I don't know how.
I don't know your exact situation, but theoretically, if the trustee screwed up and stopped, like, let's say they're supposed to make $1,000 payment, and they paid $500 instead for 2 years.
Yeah.
Chances are you would have heard from the bank at some point prior to that.
But see, that's where the bank admits now that we've been discharged out of bankruptcy. Their attorney admitted to us that they made a mistake by not saying anything when it started 2 years prior to the end of the bankruptcy. And I want to know, where did that money go?
Well, I think that you probably.
Somebody pocketed my money.
I think the trustee screwed up, it sounds like, but I don't know for sure.
Well, what recourse do we have?
Well, you could file a motion with the court to require the trustee, if they screwed up.
I would think that the trustee should be responsible for giving some kind of accounting,
Well,
how much he paid,
the-
and at the very least have to do that.
The question is, if the trustee made a mistake, would they be accountable? And absolutely. I have not seen that happen before. But if it's the bank that made the mistake, the actual creditor that didn't file a proper proof of claim or never brought it to anybody's attention, you know.
Because we're the ones, my husband and I, we're the ones suffering for it now with having to make larger house payments because of the screw up during the bankruptcy.
It sounds to me like, and this is someone from the audience saying that they were a victim of this happening to them in a Chapter 13, and they're stuck now with increased expenses over their house. And I don't, again, I don't have all the facts in front of me, so it's real hard for me to tell you what to do and what you can't do. But if a trustee screwed up and paid the wrong amount, they would be responsible. If your attorney made a mistake and didn't do something that they were supposed to do, there would be recourse against them. And if the bank is charging you for something and not crediting you for something that they should be, you should be credited for it. But ultimately, it sounds like there might be a claim against the trustee. But I don't.
You said file a motion with court, bankruptcy court?
It would be in the bankruptcy court, but I mean, it's not that simple.
No, well,
Right.
no, it never is.
But if the trustee made a mistake, ultimately they would be the ones responsible. But the way I've always seen it is they have kind of computer software that does all this. So it would have had to be a glitch in the software program, or someone actually changed something, which rarely happens. And you do get an accounting. There's a website when you're in a Chapter 13 you can go to see the progress of where things are being paid and how much has been paid into the plan and all that. And
Can you do that after you've been discharged out of Chapter 13? Can you?
I'm not sure how long the system stays online for, but I imagine if you can't do it online, you certainly would be able to get the records one way or another. But then now everything's electronic, so it should be there.
At what site?
If you go to Michigan Eastern District Bankruptcy Court, you would go look for Chapter 13 trustee, and then you would have to find out who your trustee was.
Oh, I know who it is.
Okay, and I guarantee their website tells you where to go and what instructions to follow in order to get to it.
Okay. With the trustee and a Chapter 11, would there be a trustee in a Chapter 7 also?
There's a trustee in a Chapter 7 and in a Chapter 13. A Chapter 11 does not have a trustee.
Okay.
Typically, there could be one appointed under certain circumstances, but normally there's not.
Would not a trustee be bonded or something like that? So if you had an issue?
I'm sure that they have. I've never ran into this myself, but I'm sure that they have some kind of malpractice insurance. They definitely have a bond. They have to in order to do this work because they basically are accountable to the bankruptcy court, the creditors, the trustee. And I should back up. The question was whether the trustee would be bonded, and I don't know the exact answer. Do you know the answer?
Yeah, they're bonded.
I mean, they're bonded. So
could you just go against the bond company and say they
Well,
messed up in so many words and now you get to pay?
what you
bond
do is you
company?
bring it against the trustee, and then it's their job to get the insurance company
You need
involved.
you need to find out what happened. If you were making the same payment every month, the money went somewhere.
Right.
It's possible that less money went to the lender, and if that was the case, then more money went to unsecured creditors that shouldn't have gotten. So, it's the trustee's job to straighten out the problem.
Well, but the interesting issue is if it was a secured creditor and they filed an improper proof of claim,
Yeah, but why would they get the right payment for 3 years and
Yeah,
then a lower
exactly.
payment for 2 years?
They were getting
It had to be, it had to be a
the first
glitch.
3 years. It's the last
Yeah.
3 years.
so in your situation, did you have a vehicle that was paid off in the 3 years?
I did.
And so what they probably did was they screwed up and probably, and this is just my guess, I wonder if they kept paying the vehicle creditor additional money. You really need to get the accounting and see where the money went. Because it sounds like someone got a windfall for sure.
Oh, yeah, wasn't me.
There's a detailed accounting, there always is. Shows every payment in and every payment out per month.
Well, I doubt that there's criminal activity. I mean, it is probably someone made a mistake. It would be pretty hard for a trustee to actually steal the money because, first of all, they're pretty reputable people. They're not going to do that, even though you may not think that.
They're also audited by the Justice Department regularly.
Yeah, I mean, there's a lot of checks and balances. And I think that there's a central system that actually deals with all the money. So I don't even think that they physically see it. They just see the numbers and the X's and O's. And
I mean, because I feel that the bank should eat it because they looked happened 2 years and chose not to say anything about it.
it's possible that they should. I mean, again, I don't know everything, but it's possible that you're right. It's possible.
Somebody should, not me.
Let me think. Let's get back to the chapter 13s. Now, I guess we've heard that they can get kind of complicated, and this is why I prefer someone, if they can, to do a chapter 7. A chapter 13, you pay into a plan for 3 to 5 years. So you're stuck in the system for a long time. And it's a reminder, and you don't have closure. And during this time, you could be incurring new debt that's not even subject to the bankruptcy. So it delays you actually getting your fresh start, which is the whole basis of a bankruptcy. So I really try to steer people to do a Chapter 7, assuming they qualify. Sometimes people really feel that they need to pay something back to their creditors, but ultimately, when they feel that strong, and I'm always supportive of what my client wants to do, they always say, Matt, you're right. And when you're in a Chapter 13, you can convert it to a Chapter 7 and discharge all your debts, assuming
See, our
you
debts-
qualify.
Our debts weren't great enough to do a Chapter 7. Because
Well-
we had done a Chapter 7 years ago. But, and we didn't want to do a Chapter 7.
Well, typically in the past, up until a few years ago, most people that filed Chapter 13s were people that got sick, got laid off, for some reason fell behind in their mortgage payments. And as I said earlier, you can file a bankruptcy to stop a foreclosure sale. So what people would do is they would get behind on their mortgage, and the banks were, even though they're still hard to work with, They were a lot more difficult to work with 10 years ago. So someone that got laid off would try to work out something with the bank, but the bank would just ignore them and go through foreclosure proceedings. You could file a bankruptcy, file a Chapter 13, and you could cure the default that you had through the plan. So you can spread that out over a period of time. So if you were 6 months past due, you would continue to start making your normal monthly payments, but the amount that was owed that was past due would get spread out over a period of time that you could afford. So that's traditionally why people used to file Chapter 13s.
Matt, one of the things I noticed, it seems like all of these different types of bankruptcies, people have income coming in. And it's a matter of whether their income matches their expenses. What about for people who have no income and have a ton of debt?
So the question is, people that have no income and tons of debt, what do? They clearly don't qualify for a 13 or 11 because there's nothing to pay anybody back. And they would be perfect candidates for Chapter 7, assuming everything else was in line, that the debts were dischargeable, that they were, not on deathbed because there'd really be no purpose. And, a lot of other circumstances come into play. But typically, that to me, would be someone that really just kind of needs to get a fresh start and move on with their life. It could be a husband that's unemployed, that's been laid off and can't find a job, or a wife that doesn't work that's laid off, or just a single person that is just living that can't find work and is supported by family members. That, depending on their age and everything else, because I have to look at all their assets, anything that they may have an interest in is subject to bankruptcy. So basically, when you file a bankruptcy, you're exposing yourself to a lot. People lose their houses, they lose their cars, depending on their circumstances. They can lose their inheritance. Unfortunately, the trustees, I like to call them vultures. I know it's kind of not a nice thing to say, but in a Chapter 7 scenario, they get paid a flat fee just for meeting with you. And like I said in the beginning, which you probably forgot, but most of the time, no one has any assets. So they only get paid like $60 for just meeting with you and looking at your file. But they do make money if there's assets to administer. So they try to look, they scrutinize through people's files to see if there's something for them to potentially go after to get money out of. And they do some pretty egregious things, and sometimes I'm sure we would differ on our opinions, but I don't think they have very valid claims. But the cost to the debtor ultimately ends up costing them money. So, and they end up getting something for the creditors.
If the illness caused you to become behind, and there's no money coming in, and your debtors are studying
Your creditors.
Creditors, I'm sorry, keep calling you and keep trying to explain. Would Chapter 7 help you out on that?
The question is, if you're ill and you can't, and you don't have any money, and your creditors are just driving you crazy.
You lost your job.
Because you lost your job, or you just broke. I mean, even if you're making less money, but if you have no job, you can file a Chapter 7. You can, under the Federal Fair Debt Collection Act, if you have someone representing you, you can tell the collection agent to call your attorney, and they're not allowed to contact you anymore. It's like your Miranda rights. When you get arrested and you say, I want my lawyer, the cops can't ask you any more questions. The same thing's true with the Federal Fair Debt Collection Act. If you have a lawyer and it's a collection agency calling you and driving you crazy. So that's one way to stop it. And I do that with some of my clients to take off that headache, where it's not appropriate for them to file a bankruptcy, where they're not going to get a lot to gain out of it. But they're getting crazy by these phone calls, or driven crazy. So you can do that. That's one way to stop them. Other than that, I do think there's one, I think you can write a letter. I have to check. I think that they did change the Federal Fair Debt Collection Act to say that you can write a letter to the collection agency to tell them that you only want them to communicate to you by mail, and that stops the phone calls. But what happens is, in my experience with collection agencies, is the way debt works is it gets sent to one agency, and they work the file for so many months. And then it gets sent to another agency. So if you send them a letter, you basically have to start from scratch. So if there's an attorney, it's a lot easier just to pick up the phone and say, call my attorney, goodbye. But I mean, again, that costs money, and that is work.
Costing money, Matt, that was another question I had, especially with folks, because obviously bankruptcy is more complicated than, for example, going down to the court and maybe applying for guardianship, where there's forms and you fill them out, and many clients can do that on their own. So how does somebody who's in debt, has little to no income coming in, and needs an attorney to help them through bankruptcy, how can they do that, and how do bankruptcy attorneys get paid?
It's the question is basically, how does a debtor afford to file bankruptcy when they have no money?
Yeah.
It's like a catch-22. And it really just depends on the circumstances. I would be very, very careful. There's a lot of people out there, especially in Detroit, that will charge a $100 fee and prepare your bankruptcy paperwork for you. I see people in bankruptcy court constantly getting in trouble because of doing this, because they pay someone that that prepares the paperwork and it's all incorrect, and people lose their cars because of it. They lose all kinds of things because they're not having someone that's a professional deal with their situation. And like I said earlier, that not everybody is appropriate to be in a bankruptcy. They're just not. It just depends on a lot of factors. So I would avoid those kind of people. And I frankly would avoid trying to do it on my own because it is very complicated and you don't understand completely. The bankruptcy court will waive a filing fee. It costs $306 to file a Chapter 7. You can petition the court to waive that. A lot of times what I do with my clients, depending on their circumstances, is I call it like layaway, where they just pay me over a period of time, and as soon as they start paying me, I tell them that they can have their creditors tell them to start calling me, which we were talking about earlier. So that kind of takes that a little weight off the chest. And then if it takes 3 or 4 months to pay me, it just delays the process, but eventually you save up the money and you file the case. Usually people can figure out a way to scrum up, to save enough change to do this. And it really, for me, my fees all depend on the complexity of the case, and which depends on the debtor. So I represent everybody from a multi-millionaire 2 years ago that is in debt $10 million to a person that lives in a $400 a month apartment, doesn't have any car, and just lives off of Social Security. So I represent the whole gamut, and I see it all. And I would just say be very, very careful out there. I would not recommend trying to do it on my own. This is one thing where I think it's pretty important to have counsel kind of back you one way or another. And I would be careful on looking out if you're interested in filing bankruptcy, who you talk to. It's like anything else. There's a lot of people out there that are just looking to take advantage of you and could care less of your actual problems and just want to make a buck. So you just need to be careful and do your homework.
What about a person that lose their job, lose their house and everything, and they put in Chapter 7 or Chapter 13, whatever, and they become homeless? Or they be on the street, you know what I'm saying? And then maybe they become a squatter or whatever. So what do they do?
Well, I mean, it's kind of a frustrating thing for me. The question is, what is someone that basically loses everything, even their house? How do they move on in their life? And I really wish I had a magic wand and I could wave it and make everything better for everybody. But unfortunately, my magic is getting rid of that timeline, that picture I drew, or imaginary line. I can help with the past. I can give moral support for the future, but I have no power to do anything. So, I mean, a squatter, a homeless person could file a bankruptcy. They certainly would qualify, but it would be a little sophisticated, I guess, for most people that don't have a residence to get to that point. When you don't have a house, there's more important things I think you need to worry about, like
Right.
food and shelter. So I think hopefully you would get back on your feet somehow through, I know there's programs and assistance out there, and hopefully you would get back on your feet. And then that would be a great time to kind of see someone like me to figure out kind of a plan to address your negative past and how to get a fresh start and move on with your future. Yes.
Does bankruptcy go on your credit report, and if so, how long does it stay?
So the question is, does bankruptcy go on your credit report, and if so, how long does it stay there? And it's a question everybody asks, and the answer is it does go on your credit report, and it's on there, I believe, for 10 years. But I don't think it has a negative impact on you for that long. Credit scoring is insane, and even though I deal with this on a daily basis, I don't hold myself out there as a credit score expert. But it will affect you probably for about 18 months. Yes.
Question, speak similar to hers. When you have a debt, say I said you got something in 1990, and it's now 2013, and the debt is still, what they're doing is like they'll start out in 1990, they keep it 1990, 95, and they pay 7% one else. How long can they continue to do that?
There's a statute of limitations. The question is, how long does a debt basically exist? Like when you owe someone money and you stop paying, it's a great question because it's something we haven't covered. But if a debt it's 6 years, isn't it?
6 years.
6 years. It's been from the last time you made a payment, they have 6 years to collect on it. So if they don't sue you during that 6-year period, the debt basically just evaporates and disappears. Now that's for general like credit card debt. Of course, if it's for your house, it's attached to your house and that won't disappear. And if the creditor sues you, they get a judgment, and judgment is enforceable for 10 years. And it can be renewed. And I think we're running out of time.
You guys were fantastic. Thank you both very, very, very much.